Hello, it's Jenkins, the family law vlogger here. So this is the last of the vlogs in the Stages of Divorce series about filling in for me. We're finally at the end. We're in section 5, which is a section of the form which asks you what orders you would like the court to make. Now, quite often, just to get this up front, quite often completing those boxes, you tend to say you don't know what sort of orders you want from the court, and you don't know what's appropriate until you've seen your spouse's financial disclosure. Because if you remember, going right back to the beginning, each of you fill in your Form Z and then you exchange Form Z. So you get your spouse's Form E and they get yours. And at that stage, you can then evaluate what the appropriate outcome would be. And that would be the same. It's usually the same if you're in a court context, you definitely exchange Form Z. In mediation or some other sort of dispute resolution process that outside the court, you tend still to exchange them. And then there's an assessment, usually with your solicitor, about what the finances are overall, because you've got both sides of the story, and therefore what an appropriate outcome would be. So that's the kind of caveat on this section, because the answer may well be to each of these questions that you don't yet know because you don't know the full financial picture. That's absolutely fine. You're not expected to nail your colours to the mast completely about exactly what you want at this stage in this form. Sometimes, indeed, in mediation, you don't go as far as filling in these back sections, section 4 and 5 of the Form E, because the mediator may say, well, just give me the basic financial information, and then these sorts of questions in section 5 are the sort of thing you'll discuss in mediation. But let's assume, for example, that you are filling your Form E in completely for the purposes of the court. So section 5 asks you what orders you might want to make in relation to the family home is the first one. Now, you may say, I would like to keep the family home, or we definitely can't afford it, it's going to have to be sold. So you can put that in that section if you know that answer. There's a next question in section 5, which is about whether you want there to be a clean break. A clean break is legal terminology for meaning that neither spouse is going to pay maintenance to the other. Child maintenance is separate, but a clean break means that you're each going to get on with your lives in terms of income, perhaps with child maintenance if you have children, but without spousal maintenance being paid, either because that's not what's affordable or because income is dealt with elsewhere in capital. And we'll come to that when we talk about settlements. So this is starting to be one of the boxes where you might not know. That might have to be a to be confirmed, depending on what you know about your spouse's financial circumstances. The third question is whether you're going to want the court to make any orders about pensions. Now, again, pensions are quite a technical area. There's other vlogs on pension sharing and the importance of pensions. But it may be that right now, filling in this form without seeing your partner's details or having advice from an actuary, you don't know what pension orders you're seeking. It may be you could say in this section, yes, I do want pensions to be dealt with, but you're not expected to say exactly what sort of pension order you would want. Then the next 3 sections are the last bits of section 5. One is saying whether you want a transfer of assets. So this section you might know. So for example, if there's a holiday home that you would like transferred into your name, or you would like to keep as part of any overall settlement, or if there are certain assets that you specifically would like transferred to you, then you could express a view in that box. And then the final 2 sections of section 5 are quite technical, and they're areas that perhaps you might want advice on from a solicitor. The first one is whether you're going to be asking the court for a variation of settlement. That means a variation of a trust. So variations of settlement are quite unusual in family contexts, but in family divorce contexts, but they are provided for by law in certain very specified circumstances if there's a sort of trust, a settlement that is nuptial in nature. That's going to be the subject of a very different and specific vlog on that topic area, and because it is quite niche but very important, particularly where there are family trusts or family settlements around that own assets. But if that doesn't apply to you, or you're not sure, then that box is probably also to be confirmed. Likewise, the final box in this section, which is asking whether you want the court to make an order for an avoidance of disposition, to unpick an avoidance of a disposition that's been made. What does that mean? What it basically means is if, for example, your spouse, during the course of these discussions and proceedings, before you've done your Form E, has transferred an asset that was in their name, for example, a bank account that had some money in it, has transferred it from their name to another family member, potentially for trying to avoid, for example, it being taken into account as part of your divorce. That's a disposition that the court does have power in certain circumstances to apply to set aside. And so if you know that that's the case, then that again is a box that you'd want to complete. Yes, my spouse transferred this asset from their name or from our joint names into the name of somebody else, and I would like that unpicked. Again, quite niche, and there are certain laws, quite stringent laws around that and when it may or may not happen, but that's what that box is designed to address. So really overall, section 5, don't feel you have to complete every section, don't feel you have to nail your colours to the mast on absolutely every section. If you know that you want to keep the house and you know there are certain assets you'd like to come back to you, then it may well be that you can fill those in. But otherwise, it's also okay to simply say to be confirmed once you've taken advice, and also once you've seen the other partners for me. And the very final section is the statement of truth. Right at the back of the For Me, there is a statement of truth, and then there's also a section which asks you to complete what documents you've attached. So don't forget to attach all the documents that you've referred to or which the form asks you for on the way through. If you're not sure, go back and look at the headings of each of the sections of the For Me, because that will tell you not only what's supposed to go in that box, but also what documents you're supposed to attach. And then the statement of truth. You are asked to sign the For Me, certainly in a court context, often in mediation, and you're signing to say it's complete and true. And so it's a really important section actually for building confidence around people feeling that their spouse has actually disclosed what information they have about their finances and what they know about their finances. And that is part of, we talked about this in the context of the overview for financial circumstances on divorce. It's part of the duty on each of you whilst you try and sort out finances on divorce in whatever context, so court, mediation, collaborative process, round the table negotiations with solicitor, arbitration, all of the different processes. It's a fundamental building block of all of those processes that there's full, frank and clear disclosure. So you're being asked to sign the statement of truth to confirm that you have given that. Okay, so that's the end of the Stages Divorce section about Form Z. Watch out for further vlogs about next steps once you've exchanged Form Z. And that's it for now. As always with the vlog, if you need specific advice on your circumstances, please contact me or one of my colleagues in the Mills & Reeve Family and Children team. Thank you.